Former Louisville police detective Brett Hankinson was in federal court today in connection with the 2020 raid that resulted in the death of Breonna Taylor. Remember the case that made headlines everywhere. Now, Hankinson is not the officer accused of firing the fatal shot that killed her. Instead, he fired 10 shots into her apartment that night, 5 of which went into her neighbor's home. There is no defending shooting that many wild shots, even though he and his fellow officers were fired at by her boyfriend. But wrong doesn't necessarily mean criminal. After all, this will actually be the second time the now fired detective will have been on trial. He was already acquitted in a state trial last year.
We, the jury, find the defendant, Brett Hankinson, not guilty of wanton endangerment first degree under instruction number 6. Mr. Hankinson, this jury has found you not guilty. This court, therefore, finds that you are not guilty of these charges. You are free to go, and your bond will be released.
And legally, I believe this federal case will be even harder for prosecutors to prove in the state case, where Hankinson was acquitted already. Here, they'll have to prove he intentionally violated their constitutional rights. In the state case, he was just accused of what's called basically criminally reckless conduct. Look, remember the facts? May 2020, officers in plain clothes went to Breonna Taylor's apartment to execute a search warrant. The officers claimed to have knocked first and identified themselves. A witness confirmed that he heard them do so, but that remains an issue in dispute. Kenneth Walker, Breonna's boyfriend, had just woken up and said he thought they were intruders. He fired one shot that hit Hankinson's fellow officer in the leg. Officers Miles Cosgrove and John Mattingly returned fire, fatally striking Breonna. Now, none of Hankinson's 10 shots hit her, Kenneth Walker, or any of the neighbors, by the way. So it was, again, reckless conduct by Hankinson, and that's why the Louisville Metro Police Department fired him in June of 2020, 3 months after the incident. Completely understand that. But for this federal case, where jury selection began today in Louisville, they'll need to prove he willfully deprived Breonna and Kenneth of their constitutional rights. And prosecutors argue it was, quote, an attempt to kill. I would think that will be much harder to prove than even the state's case. So it sure starts to feel like the feds are going after him again because they want to be able to say that they did. On the stand in the state case, he expressed remorse about the apartment he did shoot into.
I felt sincere empathy for them. That was something, if my daughter was shot at or bullets came into our house, that would be very concerning, and I apologize to her for that. And Miss Taylor's family, it was just, she didn't need to die that night.
So it seems to me like maybe wrong and criminal are being blurred in this now second effort to convict him of something. But joining us now is Sam Marcosson, law professor at the University of Louisville, who's been following this case closely. Professor, thanks very much for coming on. Appreciate it. All right, so there's no evidence that he targeted or shot at them because of their skin color, which is typically why this sort of federal case would be brought. This just feels to me like a second effort to convict a cop in a high-profile case. You disagree?
I do. For one thing, there were a lot of problems with the state prosecution. The attorney general who handled that case did not present certain charges to the grand jury, did not in any way get into the issue of whether the warrant itself had been secured as a result of perjury, and whether any of the officers, including Hankinson, who served that warrant that night, knew that it had been secured by perjury. And so part of the federal government's case, I suspect, in the federal case we're about to see begin, will be that part of the deprivation of civil rights was to engage in a search that was not supported by probable cause, was not supported by a warrant that he knew to be invalid, and thus there was no lawful enforcement purpose, no law enforcement purpose behind the use of force that Hankinson engaged in, and that it was excessive to fire as many shots as he did once any valid need for self-defense after Walker's shot had ended. So there's a lot in this case that will pick up where the state case never really even began.
Thank you for watching. Go to newsnationnow.com to find NewsNation on your cable provider. And don't forget to click the red subscribe button below to get more of NewsNation's fact-driven, unbiased coverage.